Hello everyone, welcome to Dosa and Donut. In today's episode, we are going to cover one of the hottest topics, that is immigration. As we all know, there is no single answer for all of the immigration issues. To discuss that in detail, we have Ms. Lalitha Alladi, who is not just a seasoned immigration attorney, but also founder of an NGO called Shakti US, which serves and supports women who are the victims of domestic abuse. She's also a part of a lobby group called South Asian American Bar Association that helps formulate the immigration policies and bills, and which we take to the Capitol Hill. So I honestly thank Lalitha for giving her valuable time, and let's dive into the conversation. Firstly, hello Lalitha, thank you very much for giving your time for doing this interview. I know you're not just a lawyer. I've seen you're into lobby groups, you're into women empowerment, you have an organization called Shakti US, you are a key member of that. So I really appreciate that you giving us this time. And we wanted to do this podcast so that, a lot of people living in US as immigrants or even as citizens have a lot of questions, especially related to immigration. So that's one of the reasons why we wanted to interview you and also have our audience too.
Thank you so much for giving me this opportunity. I really appreciate it. I think it's amazing that you are doing this as a service out of the goodness of your heart and out of a passion and interest. So that is amazing, and I think it is an important topic, maybe now more so than ever. So I appreciate you bringing me on your show.
Thank you very much. So I've read about you. I've seen your LinkedIn. I've went through your Shakti US and all that. So if you don't mind, could you share a bit about your background, your family, and how you got into this profession?
Sure. So, first of all, I'm an immigration attorney. I have my own law practice, Alladi Law, and I'm based here in Atlanta, Georgia. And I only practice immigration. My practice deals with family-based cases and employment-based cases. So that means that I'm, assisting people bring their parents or their spouses to the U.S., or I'm also assisting companies, both small and large, to find the right employees for their business and keeping them work authorized while they're here, and coming up with long-term plans if they decide they want to sponsor the green card, and how to make sure that they are here with all the legal requirements. Right. So that's what I do. You asked me also about Shakti. So I've been in Shakti since 2008. My friend Madhurima Paturi founded it, and I was happy to join her in co-founding it since 2008. And what it is it's a nonprofit where we assist South Asians who are survivors of domestic abuse. And she and I are both immigration attorneys, and so we found this unique situation that we find South Asians involved in, and that is there are many people who are survivors of domestic abuse but are afraid to ask for help because of their cultural issues that they face. And that's an added barrier when asking for help. So already somebody who's a survivor of domestic abuse is afraid to ask for help. That's due to the cycle of violence. But imagine now that you're here on a visa and you're not sure if your being a dependent visa is going to cause a problem. Yeah. And so they're afraid to ask for help, or maybe they don't understand the language, or there's a food, they're only used to certain foods. Yeah. Are they willing to move to a shelter? We want to be able to provide the resources to help them where they feel there's a safe space where they can ask for that help. And so that's why we founded that. And currently I'm the president for that, and we are always fundraising to find ways to assist those survivors.
That's amazing, because that was one of my questions which I wanted to ask you, because a lot of people who live here on immigration visa, right? Like H-1B, for example.
Yeah.
Let's say if a husband is on H-1B and wife is on H-4,
yeah.
assuming that situation, and if they went through domestic abuse or divorce, right? So will the wife have to leave immediately because she's on a dependent visa if the divorce has been approved? Or is there a workaround, that a bridge visa where they can stay and contest the case for child custody or whatever that is?
Sure. So there may be an opportunity to just change visas if they're just trying to square up their affairs and get it in order before they leave. They may be able to change to a B2 visa just to take care of those things and before they depart, if they just need a few months. Sometimes it's a question of needing to be here longer. Because their child is a US citizen and they want to be here longer. Then we may have to look at other opportunities on whether they're willing to study and maybe pursue their own education in the United States. So maybe they want to change to an F1 visa. There are also opportunities for those individuals, if they're a survivor of domestic abuse, to gain work authorization so that they're independent of their ex-spouse, and that way they can continue to work and take care of themselves and their children. So there may be an opportunity for that. So those are the kind of situations that we look at if someone is here on an H4 visa or any other dependent visa. Now, if that person is here on a green card, or their spouse is a green card holder or US citizen, it may be a whole different situation. They may have some other options available to them. There is, VAWA, where it is related to domestic abuse. It's a Violence Against Women's Act. They may be able to file for further benefits like applying for a green card. Or if they are a victim of abuse, they may be able to apply for a U1 visa, which means that you are willing to possibly help in that case, in that criminal case, as a witness. So there are some different options that we would discuss if they have that type of status.
Got it. And it goes case by case, right? It depends on if the spouse is on H1B or if he's on F1 or green card.
Yeah, exactly. Their status is going to matter. Their spouse's status is going to matter. And the reason for the divorce, if there's domestic abuse involved or not, that's going to change the scenario as well.
Got it. But if in that situation, let's say if the wife have to leave the country, like in whatever situation, if they couldn't get the F1 visa or the visitor visa approved, in that scenario, can they stay in India and still contest the case here by having an attorney?
Once you leave the United States, you're going to find it difficult to have standing to be able to contest the case in the United States. Because once you leave, remember that your H4 visa probably was terminated as soon as you divorced, right? And if you depart, you don't have a status with which to return. So what are you contesting, right? You're reapplying for a visa at the consulate, whatever that new visa might be, whether it be student or visitor or whatever. And also what's important to remember is the amount of undocumented time. So if your H4 visa was terminated because of the divorce, on the day that the divorce was finalized, that is the day from which you don't have status, unless you applied already for a change of status, okay? But let's say you didn't apply for that. From that day onwards, you are then considered undocumented or unauthorized stay. And depending on the number of days that you've remained in the United States that is unauthorized, that could lead to a 3-year ban, a 10-year ban, or a permanent ban from you entering the United States. Or you may be eligible to file a waiver. We're in a different era right now, so I don't know how successful these waivers will be, depending on the circumstances, but those are things that they should be aware of. Anytime you're here, beyond your authorized stay, the clock is ticking. And the amount of time that you're here after that is going to matter and make a big difference for your future return to the US.
Got it. And also it might impact the green card while you're getting into the green card from H1B, right? Will that impact like any illegal stay during your...
That it can impact that, but also keep in mind that if your spouse filed for a green card and you are getting only a dependent green card and you got divorced, there is no dependent green card anymore. Okay? And the other thing to keep in mind is people tend to think, hey, on my visa is good till, let's just say, December 2025. Or my I-94 is good till December 2025. But remember that your dependent visa is only good till the day you're still married to that spouse and they are on that primary status. So if they lose that primary status and they are no longer on H1B, or you got divorced, your status ends the day that divorce occurred or the day their status ended. And you're not going to get a special notice in the mail that says your status ended. It automatically ends. And that's important to keep in mind.
Can they appeal for the extension if they are contesting the divorce or whatever? If they want to go to a higher court to contest it?
It's rare that you're going to appeal a divorce because usually you're going to a mediator or things are finalized. You may come back to have a custody disagreement, to find out if you want to change the custody order and things like that. But a divorce is rarely appealed afterwards. So I don't foresee that.
Got it. Understood. So as we were also discussing about the current situation, right? There has been a lot of buzz in the news, in the social media, that you have to carry your documents, your immigration documents. Like if you are on H-1B, then your I-797 or passport, or if you're on student visa, then you have to carry your OPT card and the whatever that is. So all of these documents. So how true is that? And even for the domestic travel, they are recommending to carry all this.
That's a great question. First of all, if you have a visa or a green card, it has always been required that you carry proof of your status with you. So it is just being enforced a lot more right now, okay? And it is more important than ever that you carry that type of documentation with you. So if you are a visa holder, I would say carry a copy of your visa with you, and carry, if you have an OPT, then carry a copy of that I-20 with you if you can, maybe in the compartment of your car or wherever you're going. It would be good for you to carry that with you, okay? I mean, it's the law that you must carry a copy of your status. If asked, you have to produce it. Green card holder, that's easier because you have a green card, right? So you can carry the green card with you. But what is now different is that I am advising US citizens to also carry a copy of their US citizenship, proof of citizenship. You don't want to have to carry an entire passport with you. So what I usually suggest now is that you apply for a US passport card. And you can just do that online. You can go online and apply for it. And while you can't use that to travel, for the traveling abroad and coming back in, you need your actual passport. Before, your US passport card was sufficient to travel to Canada and Mexico, but now they've implemented that you need to carry your passport itself. So I use that US passport card as more of an ID. You don't want to carry your naturalization certificate or your passport. So you carry this with you as an important way to show that you are a US citizen. Is that where we want to be? No, but this is for your own safety, for your own protection. I will even go so far as to say that get it for your kids, okay? I put one in my children's backpack, okay? Elementary school students, middle school students, high school students, because what do we know? Right. These schools have also been raided. They are not protected, right? Okay. So when ICE can show up at schools, at churches, anywhere, carry that proof with you. I've had to tell parents to explain to their children, you don't have to scare them, but to say, if this ever happens, if this circumstance arises, here is where I'm keeping it in your backpack. Pull it out only if necessary, right? When this is a day and age when they're having to do shooter drills, right, in case somebody comes in to the school. This is similar. These are scary circumstances, but they need to know how to protect themselves.
Right. And it brings me to this question where, we also have seen that if there is a violation, right? A violation of law, be it even a traffic violation, like overspeeding, you had a ticket in past, or you had some accident in the past. Right. So I'm not sure if this is true, but this is all over social media, that you are being pulled out and it's impacting your immigration, be it for students or for H-1B holders. Yeah. So how true is that?
So students are definitely being affected right now, okay, by such traffic violations. So let me break it up. Let's start with students because that's the one that's been in the media the most recently. What happened recently was that the government performed a criminal background check of some type. We don't know what it was exactly. But then they said they flagged individuals who appeared on this criminal check. What we can tell from those who were receiving notices that the CVIS was revoked is that many times it was people with traffic violations. It was also folks who did have an arrest, but the case was dismissed. And of course, you also had people who did have criminal cases where they were found guilty. You had a combination of all of them. Okay, so the question that we asked was, but did they actually violate any of their? Did they violate the rules of their status? And in many cases, we found that they did not violate the rules that prevented them from remaining in that status, which is why so many folks filed lawsuits immediately, right? And so when those lawsuits were filed, many of them were successful. And naturally, attorneys have chosen the ones that they think will be successful because they need to immediately act on this and get this reversed. So when throughout the country so many cases were successful, the government decided we are going to reinstate CVIS and allow those things to get activated again in such a manner that those individuals were able to go back to their schools and get their visas reinstated and begin going to school again. But also there are some folks who left the country because the notice they were given in these emails that came overnight was that we are allowed to deport you. ICE can appear at your door and we can deport you not only to your own country, but to any other country we choose to be fit.
That's surprising.
This raises alarm, right? Because of what we've seen in the media as to the other type of countries to which you could be sent, right? Your family can't come and find you. It's hard to trace. These are some difficult countries, right? And so out of that fear, and a valid fear, some students left, right? And they're trying to follow the rules because this is what's being told to them, that you must depart or else you're immediately, what did I say? Accruing unlawful unlawful period, right? Unlawful presence. So they left. And some of them, rightfully so, because within 2-3 days, ICE did appear and knock at doors at the universities and take students into custody. So many of them felt that they made the right decision to leave because they didn't want to be in that position. Other students felt differently and said, no, I know I've done nothing wrong and I'm going to stay put and I'm going to fight this. And you know what? There's no wrong answer. They all did what was right for them and what they're comfortable with. And it was a difficult decision that they had to make.
Right. I mean, if the visa is going to be reinstated eventually, right? If they are confident of that. So what is that period is going to be like between when it was revoked and when it is reinstated?
It was, I want to say it was about a month to 6 weeks before these lawsuits and then finally the government changed their mind. What's also been in the rumor mill is that the government is still looking at a way that they're going to define how students' criminal backgrounds will be looked at and how they're going to get back to that situation, but maybe in cases where they meant to send the students out, right? So maybe they're going to find a way to actually hone in on the students who did have a real basis with which their visas were supposed to be revoked, right? So I think we can still expect that there are going to be more changes coming up for student visas. And I think, we just have to pay attention and see what's happening next. And until it happens, we don't know what to do next.
Yeah, I know. So if, let's say today their visa got revoked for based on the criminal background check, and they went to the court and challenged it, and after 6 weeks it was reinstated. These 6 weeks, will they be considered as undocumented stay or illegal stay, or?
That's a very good question. I mean, if I was representing them, I would put it as, the 6 weeks undocumented stay. Luckily, you have to have been here longer than 180 days to have that 3-year ban and things like that for unlawful presence. So in that respect, the harm is a little bit minimized, but it would still be something that you will openly reveal to the government when applying for future visas or green cards and explain the situation, right? That this occurred, this is what happened, when it was reinstated, I was able to get it reinstated, and this is the amount of time that I was here, with unauthorized presence.
So as we were talking about raids, right? Let's say ICE agents, it's their duty. So when they come home or come to your office or to your university, and start asking you questions, because a lot of people might panic and they might not give the they might give the wrong answers, right? So do they have the right to say that I'll speak when I have my lawyer or attorney?
They can say, I have an attorney, please call them, please speak to them, and they can give the phone number. There are circumstances where they don't have to open the door. They can look through the window and they can say, here's my attorney's phone number, please give them a call, talk to them directly. They represent me on this matter, right? And there are also certain documents that they have to show in order to pick you up, to say that they're allowed to take you into custody. And if they want to search your home, then they have to have a signed bench warrant. And so sometimes, especially when you're panicking and you're scared, or you just don't know your rights in this country, right? Right now, we're being led to believe that immigrants don't have rights and are not afforded due process. It's incorrect. Everybody who is on U.S. soil they all have they have rights, and they are afforded due process just by the Constitution of the United States. And it is not just for U.S. citizens, it's not just for green card holders, it's anybody who is on U.S. soil. And so the most important thing is to know, what are your rights? And so you can easily find this online, just like Immigration Know Your Rights. Now it's everywhere. You can pull that up, print it out, keep it in your car, keep it at your front door if you need to. And then there you can visit that to see, when do I need to have a bench warrant? For what do I need a bench warrant? Should they have a bench warrant? When do I have to open my door? When are they allowed to take me into custody? And so it's important for you to know that. You don't want to be researching that last minute.
Right, got it. So I think this is very interesting. I have a lot more questions. So coming to traveling in H-1B, because a lot of people, they face emergencies, right? Sometimes they have to travel.
Yes.
And let's say I have filed my H-1B extension.
Yeah.
And I got some emergency back home and I have to travel. And my H-1B approval is still pending, my extension application.
Yes.
And I have three more months on the current H-1B.
Yeah.
So in that scenario, will that impact me? Will I be stopped at the border? Sure. Or what is this?
Yeah, so you're not going to be stopped at the border.
Okay.
You need to carry paperwork with you that shows that you have a case that's pending, right? That you have full intention of extending it. In fact, here is my receipt notice where we have already filed. Okay. But let me tell you about a circumstance that I saw recently with a couple of cases, unfortunate cases, okay? Something that I think that a lot of people overlook. As we talked about, people place this huge importance on the visa stamp in their passport. Don't get me wrong, it's important. But I want people to start placing importance on their I-94. Okay. There are two places we can find the I-94, okay? Number one, when you apply for these change of status, extension of status, all of those, when it is approved, at the bottom, there is an I-94. When you cross the border and come back into the United States with a visa, they issue an electronic I-94. So please familiarize yourself with the website where you go online and download your electronic I-94. Now, keeping these two things in mind, the situation that arose for one or two people recently is a person applied for their H-1B extension while they're here in the United States. They departed. They went home to do whatever they needed to do, and that's totally fine, nothing wrong with that. And then when they entered the US, what had happened was already the H-1B extension was approved. Okay. So as you know, when you're extending status, usually you're able to extend for 3 years. Right. So since it was approved and it had reached their home in the US, right, that approval notice was sitting there with an I-94 that was giving them a good 3 years. Right. But when they entered through the border at the US and the officer stamped their passport and issued the electronic I-94, there they were only able to provide status up to the point of the passport expiry, which in their situation was probably, let's say, 6 months. Okay? So this individual comes home from the trip. They're excited to see that in their mail is their approved 3-year H-1B, and they think, I'm good for 3 years. And they think they're sitting pretty, and they're sitting here, let's say, for 2 years, until they suddenly realize, because of some conversation, that, oh, the I-94 that I got that's electronic, when I cross the border, that is my actual I-94 now. They're shocked and then they're scared and they're worried. Rightfully so, because whatever I-94 was issued last is going to be the ruling I-94.
Okay.
And so, in this circumstance, they did not have status for a year and a half.
Oh.
Right?
Yeah.
And so, they are trying to follow all the rules, but just that they weren't aware of the situation. And so, I'm really trying to make people aware that they need to monitor their I-94s very carefully because it will make a big difference in your case.
Got it. So if my H1B got approved while I'm in India, right?
Yeah.
The extension.
Yes.
So do I have to go for stamping Dropbox before I return, or can I just return because my previous H1B is still valid?
Yeah. No, you will be fine if you show your receipt notice, right?
Okay.
You have your receipt notice that you filed for an extension, and you have your old H1B stamp. Again, as long as your H1B stamp is still valid for your entry. So let's say your prior H1B expired in, here we're in May, right? So let's say your prior H1B stamp expires in October.
Okay.
As long as you are entering the United States before October, you can show your current H1B stamp, because that stamp is good for that period, and your passport validity, and what they'll give you at the border for the I-94 will be no more than that either the H1B stamp or the passport, which is why it's so important that if your I-94 got approved from USCIS, the timing is going to matter. So in a way, you're kind of hoping that it gets approved after you enter the United States. So it's the latest I-94.
Yes.
Yeah.
Oh, that's a very complex. Yeah, it's very complicated. I know we are living here since a long time, but we don't know a lot of these nuances, and a lot of people doesn't know. Though we don't intend to do it.
Yes.
It's just our, the lack of knowledge,
Yes.
which could lead us to, some potential issues.
Well, one good thing I will say is among South Asians, especially about H1Bs, most people are talking to all their friends and their family and stuff like that. So they have a little bit extra knowledge that I may not always find because the community just likes to share this knowledge with each other. And so in some ways, we're a little bit more privileged in that, but it is important to always stay abreast of the latest information.
Got it. So I have one other doubt since a long time. So usually when we go to the interview process for F1 or H1B or for B2 or B1 for that matter in India, right, or in any other country, and the USCIS clears, they do all the background check, your DS-160, they approve and they say, okay, your visa is granted. In spite of that, I've heard cases where people are stopped here after landing here in the US. So with that, a lot of people have this anxiety while they're traveling, throughout their travel. So is there a way that they can, legally ask a question or challenge on why it has been done, or is it like?
I haven't seen the circumstance yet. If they just went for stamping and they're coming in, why you may have two different scenarios happening, right? Because you would just question, not much has happened between that date and this date. So I don't know that that's necessarily the scenario in which that is occurring. You may have people who have their stamp and now they're going for a different visit and something else got flagged. So when they're entering, they're just thinking, hey, I have a visa, I'm fine. And then when they're crossing the border, that issue is being flagged, they're being questioned and maybe being pulled into secondary inspection for further questioning. Usually it'll be something like that. That's what I suspect.
So even if it is for the first time traveler, like first time they got the H1B or student visa and they flew here.
Well, they still need to be able to answer questions correctly, right? It's all about being forthcoming and answering the questions to the satisfaction of the officer. So what if, yes, you got, let's even just go with the B2 visitor stamp, okay? You just got your visitor visa. You come to the US and they ask you, how long do you plan to be here? And you're like, yeah, I'm going to apply for a green card. Well, I can't let you in, right? visitor visa is a visitor visa. You can't be staying here to apply for a green card because then your intention is wrong. It is either you're trying to enter fraudulently or the intention is wrong. That is not the basis of a B2 visitor visa. So the officer has no choice but to turn you around. So there are scenarios where the officer has every right to turn you around. You need to be here for the reason that you say you're going to be here. Or what if you're coming here with a visa that you're not supposed to work on, but you're saying you come here to work? Absolutely, the officer is going to deny you entry and turn you back around. So that'll make the difference.
So if you're all good, let's say you're legally coming, but even then you will not have the due process to do here, right? You'll not be able because you're not on the US soil, right?
Yeah, you don't have a right to an attorney at the border.
First bill which we are talking to.
Correct. You do not have the right to an attorney when you're crossing the border, regardless of your status. Green card holder, citizen, it doesn't matter. It's only when you,
For the citizens.
Yeah, there's no right to an attorney.
Okay, got it. Okay. So to dive into the next question I have is, I've seen this situation, like I've also seen this in Facebook groups and also spoke to a lot of people. So there is a situation where, a child came to US from other country when they were 6 months old or 1 year old, right? And right now the wait period for the green card, especially in the EB2 category, is like indefinite, right? And their parents have no way, they don't foresee getting a green card. And the child turns out to be like 2021 and he was brought up here in this country, pursued his education, all his life was here, right? At 21, the child who was on a dependent visa on H4, has to go into F1, right? So there is a good chance that the F1 can also be denied, right? And should the child stop his education, discontinue, and also they'll lose that in-state status, right? So I'm just curious on, how those situations will be handled legally.
Those are some excellent questions. You're absolutely right. So if, let's say, a child came into the US with their parents, legally, they are documented, they're here on an H4 visa, they've been here their entire life, there is a good chance for many of these cases that when the parents are getting their green cards, by the time they actually get their green cards, the child has aged out. They're past the age of 21 and they are not going to get their green card. Now, one small caveat is that the attorney should be able to do a calculation where there's an exception for some, they're now adults, but let's call them still children in this case, the child of those parents, right? And there's a calculation that's done. That's a complicated one that has to do with the amount of time that a case has been pending versus when the child first applied and all that. There's a calculation that's done. It's under the Child Status Protection Act, CSPA. And if that amount of time they pass that test, then they are still eligible to get their green card. So there may be some children who luckily fall in this area, okay? But then we're now talking about those who are not going to pass that test. So if they're not going to pass that test, you're right, they'll have to look at other options. Maybe they start applying a little earlier. Oh, no, they can apply for an F1 visa and they'll have to start their own process of doing what their parents had to do. F1 to H1B to green card application and so on. They may have to pay an out-of-state tuition and it changes midway. That's true. They may have to. That's going to be dependent on the school and their rules, right? So maybe they're able to show that they've been in the United States for this long, and that might be something the school will look at instead of thinking of them as a foreign student. But then again, they're going to issue them an I-20, which is only for foreign students, right? So they may say, no, you'll have to pay the out-of-state tuition. Most likely, that's what they're going to want to do. They want to collect that full fees. So I expect that is what they'll do, is that they'll try to ask for the full fees.
Full fees, okay. So in that case, if the child has to probably start the F1 visa, change of status process even before they get to 21, right? Or can they start after their 21st birthday when they lose their status?
No, you don't want to wait to lose a status because then you're here without a status, right? So you want to file for a change of status. You can only change status if you have a status to change from. If you lost your H4 status, You don't have a status to change from. You are now undocumented. So you want to apply while your H4 is still valid at the tail end, right? So you can apply, 2 months before your H4. As long as your F1 change of status has been filed prior to your H4 being terminated, it's okay that it goes beyond that I-94 period only because you've already applied in time. Right. And so while it's pending, you are still in status. Okay, while it's pending, you're still in status. Right. Now, if it gets denied, you've lost your status.
Right? Yeah, that's right. So that's a sad thing to know because it's very uncertain for the kids because they feel that they are Americans because they have lived here all their childhood and they have to lose their status.
It's a very difficult position, and that's immigration attorneys have been talking about this for a long time now that we need immigration reform. I think there are arguments from both sides on what immigration reform means. We're talking about country caps and country quotas and all of that, but right now we're not seeing any changes that's going to positively impact this at the moment.
So the indefinite wait period for the people in the EB2 of 80 years, 90 years, I think I've seen that last time it was around 120 years, which sounds very unrealistic. But yeah, that's what it is. Yeah. So I know you are also a part of the lobby group, right? Yeah. And is the lobby group also working on this, green cards for EB2s and to remove, probably an alternate to a country cap? Or is there a way that, they can get an employment authorization early? Like, let's say I have my I-140 filed a couple of years back. Right. Can I get the employment authorization early? Is there a scope to get the EAD early and wait for the green card? Or are they both tied together?
Right. So I'll start with your first point, the lobby group. So I'm part of the South Asian Bar Association of North America. I'm on their board, and I've enjoyed this association for a number of years. And one of the things that we do is every year we lobby at Capitol Hill by speaking to senators and representative offices about the issues that affect our South Asian population. Among those issues is immigration, okay, naturally. This year our focus was mainly on immigration because we recognize that this is the hottest topic and that needs the most attention at the moment, okay? And so we advocated this year when we met with congressional offices on both sides of the aisle, because we are a bipartisan organization. So we met with offices from both sides of the aisle, and we spoke on a few different topics. One thing that we spoke about was actually about having representation at the border. So as an example, I have clients who tell me, Lalitha, I'm about to travel and come back to the US, but when I do so, I'm generally nervous because I'm not sure what to believe in the news. In case I get pulled and asked all these questions, can I give you a call? I'm going to keep your phone number. Yeah. At this time, I have to tell them, I'm happy for you to keep my phone number on you. However, the law does not permit you to give me a call when you're crossing the border because there is no right to counsel when you cross the border. Okay. So one of the bills that's on the floor is for our right to counsel. Okay, when crossing the border, when you are perhaps being held in secondary inspection, which means a longer questioning, usually an hour or more, then we believe that you should have a right to counsel so that you know what you're answering, right? One, people are nervous. Two, they don't know what they're answering. They're not sure. I can tell you that when I talk to people, they're not sure what the difference between an immigrant visa, non-immigrant visa, green card, permanent resident, they're not sure. And sometimes you may incorrectly answer, yes, that is what I am an immigrant. But what you mean is, I'm here on a visa. Right. And so you may not be familiar with the terminology, and you're answering it incorrectly, and that could land you in trouble. That's why you have to have an attorney to help you through that. And like I said, you're nervous, or most importantly, you may have a language barrier, right? Yeah. So when you have that language barrier, I can't imagine answering these questions if someone's talking to me in Spanish. Yeah. right?
Right.
I'm not going to know these technical words.
Yes.
And so we have to put ourselves in that place to say, yeah, it would make the most sense to give them an attorney.
Right.
And what you've probably seen being blown up in the WhatsApp messages is elderly people have been asked to sign away their green cards. Okay? And when they have stayed outside the country for more than 6 months, perhaps. But many of them have, although they stayed outside for a longer period of time, many of them had a valid reason to do so because of a health condition or someone passed away or, some valid reason.
Yeah.
And those are reasons that normally you can argue or bring to court and prove such that you're allowed to maintain your green card. But imagine that an elderly person, again, probably having a language barrier, who doesn't understand the law, they've been asked to, they're pulled into secondary inspection, they're scared of what's going on,
Right.
and they're signing a document, they're not sure what they're signing, and what they're signing is giving up the green card.
Oh.
And then you turn back around and you're returning to your home country.
Right. And they cannot have a lawyer or attorney fight on.
At this moment, you don't have a right to an attorney
Okay.
there. And so that's why we argued for this right to counsel, so that in these situations, in these circumstances, someone can represent them because they have certain rights.
Right.
Right? And so we're saying that this needs to be an added right. The only time you have a right to have an attorney at the border is if you're being accused of a crime. So, someone's being held because they're being, held for smuggling something in. Well, now you're being accused of a criminal charge, so you have a right to an attorney. That's different. Okay? So that is one thing that we argued for. The second one is about sensitive locations. So I'm sure you've heard about how, there have been ICE raids at schools, at restaurants, at churches, you name it. At this point, they're able to go anywhere to arrest folks. For a while, there was a law that was, held certain locations more sanctum, or I should say more sanctimonious, and saying, let's not go into those areas to arrest people for deportation. Right. That law has now been rescinded. That order has been rescinded, and so now they're able to go anywhere to make these ICE arrests. Right. So the new bill that's on the floor that we are advocating for is about sensitive locations like schools and places of worship. Okay. And I think that even if we cannot agree on both sides of the aisle for all of the locations listed on this bill, I still feel that there can be an agreement that's reached on both sides that we can agree on, like places of worship, right? Where these arrests need not happen. Right. They can find a different place to do this. And so that is primarily what SABA North America was advocating for. Okay. And, that's one of the things. We also talked about the topic we just discussed, F1 visas, and helping to protect these students, keeping an eye on this issue, because we know that there's probably more coming down the chain. And so we just need to keep our eye open. There are no bills right now on the floor related to this, but maybe there needs to be, right? And so we're just keeping an eye out on this issue because it is changing the workforce. Right? They're not just students. As we know, many of these students, when they graduate, they are now working in the field. Right. They're working on OPT. They're sometimes working while they're in school on CPT. Right. And what does that mean? It's not just affecting large companies like a Coca-Cola here in Atlanta or these big corporations, but it's also affecting the small businesses, right? Many of these are small IT companies, and they're hiring folks, and you imagine that you only have 10 employees and 2 or 3 of them aren't able to come to work. That's a huge impact on your business, okay? And it's affecting then the person who's employed them, right? That person, that company could be American, right? Yeah. That's affecting, there will be a trickle-down effect. We should never think, it's only affecting that particular visa holder, this is not going to affect me. Right. But it is having a trickling effect to the economy then.
Got it, yeah.
Yeah. And we also talked about, with this F1 visa, how it's affecting the schools. these students are paying full tuition, as you just talked about, right? Foreign, you're paying out-of-state tuition.
Right.
If the schools are no longer going to get this type of full tuition, what are they going to do to make up for that money? Yes, I'm a US citizen. My children are going to go to school here. I know they're already going to pay exorbitant fees to go to college, but I need to plan for the fact that that's probably going to go up even more. That's going to impact your US citizen, your green card holder.
Right.
This is going to impact our economy in general. Got it. And so these are points that some of the offices had not considered, right? It's an immigration issue, it's an immigrant issue is not the right way to think about it. This is affecting our entire country, our entire society. It affects all of us. And so those are the kind of points we made and brought to light because it's important to know what your community thinks and what your constituents think. Right. With that in mind, one thing we really ask is that members of our community write in to their senators, to their representative offices, and let them know how you're being impacted because they want to hear from you. Okay, especially if you're a constituent of theirs, right? So that means imagine a US voter, right? Your family may not be US citizens, but it's impacting them. Write to your representatives and let them know how this is impacting you and the bottom line. They want to hear from you because if it's impacting their constituents, they are concerned and you are top of mind. And they need to know.
No, I think that's a good point that, if people are aware of what they can do legally in the process, okay? Because activism is not the solution for everything, right? There is a legal process, there is a legal due process which we can do without breaking any laws. So I think that's a very good point, which is a takeaway for all of us. Coming to one of the questions related to H-1B again, right? Let's say if a person, I know a case of a person who lost his job today, like a couple of months back. And they'll have that 60-day period, right? Let's say if that person finds a job on the 57th or 58th day, so what can he do? Can he, because he'll have just 2 days more, right? He got the offer, but he has to go through that due process to apply and the application has to be sent to the USCIS and he has to get a receipt, right? So what can he do? Because if he goes back again, his visa status will be in jeopardy, right? And he has to go through the stamping and all this again. So what can he do in that situation?
Yeah, there are a couple of options here. In this scenario, one, they can immediately apply for a change of employer, okay? And as long as the application has reached USCIS within that 60-day grace period, they still have status. Okay, and they are eligible to have the status remain to change to the new employer and remain on H-1B. Now, if it's expiring in 2-3 days, getting all the paperwork sorted, get it ready, filed, all that may be difficult. They may consider changing temporarily to just a B2 visa, taking a breather and saying, let me gather all my documents, get the employer's documents together, and maybe they just want to get a visitor visa, so they're not working. They're just here, just here as a visitor at that point. And they can apply for that B2 change of status and then follow it up with a change of status to H-1B. It won't be called a change of employer, it's called a change of status because you applied for a B2 change of status. So from B2, you're now moving back to H-1B. So that's one second option. Third option, if you do return to your home country, you can apply from there for your new H-1B. Right now, we're not hearing any buzz about H-1B visa appointments being cancelled. We do know, however, that very recently, a day or two ago, F1 visa appointments are being stalled. And consulates were told not to take any new F1 interviews, at the consulate. We're not hearing that about H-1B right now. So if you ask me today, I will say that is also an option that you return and you can file from there. Depending on your circumstances, that may be what you want to do. So they have these three options.
So, if they go back to India, right, and they apply for the H-1B again. So will there be a consular process if they do a change of status here from H1 to B2 and again B2 to back to H1? Will they be required to go back to get the stamping done for H1B, because there is a consular process too, right?
Yeah. So there is sometimes a misconception that as soon as you get a visa that you need to go immediately to go to get stamping done. Remember that the visa stamp that you have on your passport purely is for travel. Okay? Because the approval notice you receive, so long as you filed it as a change of status, number one. So let me backtrack. When you apply for an H1B, you have two options. You can file it as a change of status or what we call consular notify. Okay? If you file it as a change of status, then the minute it is approved, you are immediately in that new status, H1B. If you applied as a consular notify, you're saying whenever I am ready to change to that status, I will go outside, I will get my stamping done, and from the moment they then stamp my passport, only I am an H1B status, and I will come back to the US. So it depends. Now let's pretend that we are only talking about the folks who filed it as a change of status. Anytime you're filing a change of status into a new status, so from H1B to a B2, B2 to H1B, as long as you have the approval notice, you are already in that status. All you need is your approval notice, which automatically has the I-94 at the bottom of the approval notice. So that's the length of time for which you have status in the US and you may remain here. The visa stamp from that point that you think you need to get, the sole purpose is only for re-entry into the United States. It is the document you require to show at the border to enter the United States. So if I'm not planning to exit the US, I can stay here on this approval notice, and I may never need a stamp. You only go for stamping if you know you're going to need to travel, then you need a stamp to come back in. So maybe for work, you now have to travel to Germany, Mexico, wherever. Well, your stamping usually needs to be done in your home country. So like when I used to work at Siemens, for example, our clients, some of our executives had to travel quite a bit. So they'd go to their home country, get their stamping done so that they could continue to travel to different countries for work.
So, I mean, for stamping, as we are talking about stamping, right? So is it necessary that I have to go back to my home country for stamping, or I know it's close by, right? I can go to Mexico or Canada or Bahamas or any of these places around here.
So we call that third party stamping, okay? Meaning you're going to a country that's not your home country. Really, that should be reserved for situations where you are now primarily either working in that country or you're living in that country. For maybe you have, you're on a visa there. For, and you're working there, or you have a reason like that, that would make more sense. So let me give you an example. You may be a citizen of India. You worked in Canada for a time, and you are now a green card holder, or whatever they call it there, permanent resident in Canada. And you're right now on an H1B in the US. Well, you're a permanent resident in Canada. You can go there and apply for your visa there because you can show that you're a permanent resident, right? Or maybe you have a work visa here, but you already have a work visa elsewhere also, and because you have to spend significant amount of time working there. And so you can show that you're also working in that office quite frequently, and it would make sense for you to do this, and it would be sort of a waste of time for you to go back to your home country. Without that, it is not advisable for you to go and do it in a third-party country, just because it's next door.
Okay. I mean, even for visit, let's say I'm traveling to Mexico for on tourism visa, just to go around Cancun and all that. Okay, it is not. Okay, got it. Okay. So I think I've asked you a lot of questions, and there are a lot of questions, going around in my head. So maybe one last question regarding the EB2 and EB1, EB3 categories, right? So there is a long wait line for EB2, right? So when my priority date, let's say my priority date is 2019, and now I got a promotion or something, and if I want to upgrade to EB1 or downgrade to EB3, will that impact my priority date, or in which queue will I be? So that's one.
Very good question. So First of all, the priority date remains. That's the good news. Okay, so when you upgrade or downgrade, you get to hold on to your priority date. That is your place in line for an employment-based green card. That's the good news. So there was that time when, there was this retrogression and all this stuff that, and all that happened where EB3 was moving faster than EB2. And so people did downgrade to EB3 so that they could make it move faster. That is the right strategy at that point, right? Why would you wait additional years for no reason? As far as EB1, even that was at a point where it was current. Right now it's not current, but it's still a lot faster. And so you may need to sit down and talk to an attorney then to see what strategy might work for you to apply for an EB1. Now, I will say, people are very hopeful when they come to say they are all outstanding and they're all extraordinary to file an EB1. I have to give them the bad news in a gentle manner that maybe you're not as extraordinary as USCIS thinks. Okay, or outstanding as USCIS thinks. And it is a difficult conversation to have. But there may be opportunity for you to come here as a multinational manager or executive. And that involves a certain amount of strategy, certain amount of sacrifice to maybe have to be out of the country for a few years. But it may be a really viable solution for some people. And so that's something that they can look into. So it will depend on that individual, their background, their education, their experience. And it is a very case-by-case scenario. Yeah, but there are possibilities.
Is there also a possibility, let's say I'm in another country or I'm in India, right? For that matter, and I've never been to US, okay? Not even on student visa or I'm not on H1B. Can I do an employment-based or I-140 directly from India to US? Is there a...
Nothing is preventing you from doing that.
There is a possibility.
Yeah, there is a possibility. I guess the reason that we don't talk about that much is I'm thinking from the employer's perspective. Which employer is saying, before I test out an employee temporarily on a visa, I want to go ahead and sponsor them permanently. That is super rare. Right? That is why we don't see that circumstance. But is it possible? Absolutely.
If I feel I'm exceptionally good, okay, can I do my own application from there without an sponsoring employer?
From there.
From there.
It's possible to have the I-140 filed and then, it's possible. It's possible. I have to say, I haven't really seen that happen from another country.
But there is a...
you can file an I-140. Yes, correct.
Okay. So on H1B here, right? A lot of people are interested. They have a lot of ideas to start a business. Okay. So what is the best way for them to do? Because I don't think they have to be on H1B tied to the work visa which they are permitted to do, right? And if they start their own company, right? Any other business, it could be STEM or it could be non-STEM. I could do an AI startup, okay, or I might do a restaurant, right? So what is the legal process to do that?
The thing is with H1B, it is an employment-specific visa, right? So it's hard to say when you say they want to start their own business. What you can have is have more than one job, okay, where you can apply for a concurrent H1B. So you have your current H1B, you can apply for the concurrent one for the second job. They also have to go through the same kind of rigor, and you can do that. And we do have a few folks who do that. They're working full-time here, and then they're working maybe part-time here. That's an option. Until you have that EAD from your adjustment of status, though, you don't have that type of flexibility that you're referring to. And so that is difficult. You will have to apply for some other type of visa unless you're willing to invest as an EB5 or a whole nother thing. But if that was the case, you would have done that to begin with, right? You may because then you can just get a green card with the EB5 route. So
awesome. Thank you, Lalitha. This is very insightful, and I think I have asked you a lot of nuanced questions which are not regularly available over the internet in the straightforward documentation process. But I think this is great. I really appreciate your time, and I know it's not easy. You're such a busy lawyer. You're into various organizations, you're into the lobby group, and I really admire that what you're doing for women support from Shakti. It's really a great job, and I think a lot of people who have maybe they are not aware that your organization is there. I know a lot of folks here locally here know that about Shakti, but I think based on whatever we have done, whatever conversations we have done, our viewers might know that they can approach you through Shakti if there is any kind of domestic abuse which they are facing. They have a voice to represent them.
Absolutely. Yes. Anyone can feel free to reach out to me. And if our organization that's based in Florida is not able to assist, we will always connect them with an organization in their state that can help. Because we are a sisterhood community that is helping each other because we want them to be safe.
Thank you so much, and hope you enjoyed the conversation.
Thank you for having
Thank
me.
you.